Thank you all. I feel very honored to be here with all of you today and count all of you my friends, and it is an honor to do so. I am aware that we have got people here from agencies, and I hope they know how welcome they are. And I want to explain why Nora Razier and Jenna Whitlock are not going to be speaking today, and that was my call. I originally pushed to have them included on the agenda, and after putting out some feelers and getting some feedback, I felt maybe it would be good to have a more free opportunity for folks to share their concerns and their ideas, and that this would be kind of a rancher-to-rancher session. That said, we are very grateful for our partners because our federal land managers are our partners, and we will not succeed without them. So Nora and Jenna were very gracious. I understand Jenna may be here. Jenna, are you here? Welcome. So we've got the state director for BLM with us. And just want you to know that we're all here in a spirit of wanting to move forward together in peace and in harmony. I hope you know that I personally and the governor's office are very sensitive to your fears and your frustrations, as well as to your anger. And often you have state government people come to you or you go to them and they listen and they say, we feel your pain, and then nothing happens. And we want to let you know that we're going to move well beyond the we feel your pain stage. We are preparing to be very active partners in supporting you. As was just stated, you are an essential part of Utah's economy. You're part of the fabric of the culture of this state, and just an important part of the lives of so many for generations, and we want you here for generations to come. I had a brief conversation this morning with Steve Ellis, who is the Deputy Director of the Bureau of Land Management, and he said to tell you that he is totally behind public land grazing and that on his watch it will persist. He's from an agriculture background himself. Obviously, we do bump into some challenges. And I think that's because we all need to acknowledge that elections have consequences. This country elected President Barack Obama 7+ years ago, and then re-elected him a little over 3 years ago. That was a strong statement of support for policies he represented and directions he indicated he wanted to go. Now, clearly, many of us here in Utah are at odds with much of what he has intended to do and into the way he's interpreting and applying policies. But that is about elections. That is about democracy. And that is about the system we live within. Our office has been very diligent in being active in all of the planning activities of the BLM and the Forest Service, from forest management and BLM resource plans to the sage-grouse plan revisions, And we've sat side by side, hour upon hour with these agencies, promoting positions that we feel are advantageous to you and to other Utahns. We have had a lot of cooperation at the local level, and I want to commend the support we've had, the understanding, and the willingness to accommodate so many of the requests and acknowledge the concerns. But what often has happened is after we have come to agreement, something goes to Washington, D.C. for final endorsement, and it comes back different. And that is not the fault of our local players. It is just the reality of this election business. And, we've got an important election coming up, and, it's really going to be significant in terms of the direction this country continues to go. But our office is now prepared to get on the ground. We've tried the the strategy of writing letters, and we have sent countless letters, both to Washington and to local partners as comments, the consistency review from the governor, and those have largely been ineffective. So our efforts to mold policy from this level to the DC level have not been successful for the most part. We also have differences in terms of the way we would interpret the law. And those differences may end up having to be resolved in court, as legal differences always are. Or perhaps if there's a new administration, they will choose to interpret legal directives in a different way, and we won't have to go to court. We would like to resolve all of our issues cooperatively and peacefully. But policies that are developed and debated are primarily DC-driven. There aren't very many policies that State of Utah, BLM, or even the Regional Forester's Office are putting together themselves. They are more in the business of implementing the directives that they get from their bosses. And then the people on the ground you're working with are doing the same. They're members of your communities. They want to hold on to their jobs too. And for them, holding on to their job means following the directions they get. And for the most part, I think these agents and representatives are anxious to work with us. They want you to be successful. They're successful when you are. And I think together we can work towards that end. We are beefing up the staff in the Public Lands Coordinating Office. Reg was our first additional staff member whose job is primarily reaching out. He is a former rancher himself. He is now managing the Grazing Resolutions Working Group, which we have established, and he's going to tell you more about. But we will be available to be at your side and in your meetings. We want to be there to help build understanding, to support you when there are legal arguments to be made, and hopefully to rebuild the trust and the collegiality that I think is going to be essential if we're going to get past some of the difficulties we now face. So my request to you is work with us. Be your best selves. Ranchers and farmers are the very best people in the world. You're the salt of the earth. You're the foundation of everything that keeps our nations going. You produce the basic things we need in our society, and we are grateful. Continue to be who you are. Unfortunately, events such as happened with the Bundys in Nevada and the things that went on in Burns tarnish the image you all have. The general public out there, public that doesn't live here and doesn't maybe understand up close and personal what you're up against, sees these lawless people and they get a bad notion of Western ranchers. We can't afford to let that happen. We need to stand up and show them that we have white hats on, even if we've got black hats on, but that we are good people and we want to work through a course of law to resolve problems. So my request to you is to work with us, work with your federal partners, and to be part of the solution here, not part of the problem. Thank you so much. I'm just going to tell you, Tony Rampton does lead the attorneys general that support our public land office. They are actually in our office, and I work day to day with Tony, and he is so in your court. But he's also a man who understands the law, and he's going to talk to you today about a lot of what we're all up against and things that we can move and things that maybe we're stuck with. But Tony's great.
Good morning. It's very nice to be with you. Thank you, Kathleen, for the kind introduction. Once again, my name's Tony Rampton. I'm an Assistant Attorney General. I'm the Director of the Public Lands Section within the Attorney General's office. And our section, as Kathleen says, services and works with PLPCO, the Governor's Policy Coordination Office. I've been involved ever since I started working for the state 4 years ago with land issues. That is public land issues. That is federal land issues. That's really all I do. And one of the primary areas that I work with is the RS 2477 lawsuits. We have 22 lawsuits pending, over 12,500 roads that we're litigating. And in conjunction with those lawsuits, we over the last 3 years have been deposing, that is taking the depositions of older ranchers and older residents of the state, throughout the state, that have used and worked on, played on, hunted on, fished on the roads throughout this state, the roads that we're claiming as RS 2477. And one of the things we do in order to get ready for those depositions is we go out with the witnesses and drive every single one of the roads that that witness has personal knowledge of. A lot of these witnesses are ranchers. And I have literally spent hundreds of hours in vehicles with older ranchers all around this state, listening to their stories, traveling their allotments with them, understanding their families' histories, and it's been a remarkable experience for me. I've gained an enormous respect for and appreciation of the ranching industry in this state and the history of the ranching industry in this state. A lot of these witnesses are fourth, fifth generation ranchers whose families have been here since the 1850s, sometimes on the same allotments. But I understand your way of life, although looking at me the way I dress, you wouldn't believe that, but I do. We have been involved in grazing issues in the public land section as well. We were involved with a lawsuit that forced a grazing EIS in the Grand Staircase that I'm sure many of you are aware of. But more than that, we have for some time been watching grazing issues as they've been developing. And we're aware, and have been aware for some time, that your industry is under attack by some NGOs and environmental organizations. I mean, there are some organizations out there whose primary purpose, primary objective, is to remove all grazing from the public lands. You know who they are, you know who the organizations are, you know the individuals that are involved. And frankly, the environmental movement has been successful for a number of years in shaping federal land policy. They're well organized, they're well funded, they're dogged in their determination. And in some cases, maybe a lot of cases, they simply wear federal agencies down. As Kathleen said, my office, that is the Attorney General's office, and the Governor's office through PLPCO, plan to get more actively involved, and Redge Johnson is going to talk to you about just how that's going to happen in a few minutes. But we all recognize that it's time to push back and push back hard, and that's what we intend to do. We intend to restore a sense of balance to the federal land policy as it relates to grazing. A policy that I believe has been out of balance for many years. And I think that weighs on you daily. I have been in attendance, and what I want to talk to you about today primarily, I have been in attendance in the last 2 or 3 months at several meetings of Paiute ranchers. And in those meetings, there have been presentations made by various individuals that have addressed what, in their opinions, are your property rights with respect to your grazing allotments and your grazing permits. And it was hard for me to sit and listen, because I knew that some of the things, just based upon my knowledge and understanding of public land law, I knew that some of the things they were saying are just not legally defensible. And at those meetings, after these presentations were made, I stood up and cautioned the people in attendance. And there were a lot of ranchers in those meetings, and they were angry, and they're scared, and they want to hear that they have rights. They want to hear that they have leverage. And I understand that. That's human nature. But what I told the ranchers, and what I want to talk to you about today, is that if you take certain actions in protest, there are going to be consequences. And we're watching now in the press some of those consequences playing out. And so what I want to talk to you about this morning is I want to walk you through some of the arguments that are being made and some of the arguments that are being presented to you that give you the impression that you have greater rights than you really have. And the difficulty for me, and what I've cautioned against these meetings, is that some of these speakers are advocating that you take certain actions, including surrendering your grazing permits to the federal government and going out and grazing on the public lands without permits. There are other things that have been urged at these meetings outside of the law. And I want to convey to you directly from Sean Reyes, the Attorney General of the state of Utah, that he fully supports your efforts to preserve your way of life and your livelihood, as long as you stay within the law. So what I would like to do this morning in the next 45 minutes, 40 minutes, is walk you through some cases. After sitting through these meetings of the Paiute Ranchers Association, I went back to my office, and one of my associates and I, David Halverson, who's sitting here on the front row, thank you, David, we looked at the various issues that had been raised in these presentations. to find out, one, if the representations that were being made are supported by the law, and if not, what rights are actually there and how they interrelate. The first issue that I would like to address is the issue of whether the enclave clause in the United States Constitution, that's Article 1, Section 8 of the United States Constitution, whether the enclave clause governs the ownership of federal land and limits the ownership of federal land. That is, does the enclave clause set forth the limits of the federal government's right to own and regulate the public land? That issue has been dealt with many times by the courts of this country, including the United States Supreme Court. The first case that I want to mention is a case called Butte City Water versus Baker. And could I have that first slide? This wasn't a grazing case, this was a mining case, but nonetheless it sets forth what actually governs the ownership and regulation of the public lands. It's not the enclave clause, it's the property clause. So anyone who tells you that the enclave clause governs the public lands is not accurate. And I'll quote from this case, and you have it on the screen before you. The authority of Congress over the public lands is granted by Section 3, Article 4 of the Constitution, that is the property clause, which provides that the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. In other words, Congress is the body to which is given the power to determine the conditions upon which the public land shall be disposed of, the nation as an owner, the nation as an owner, and has Congress the principal agent to dispose of its property. This was a case that was decided back in 1905, and at that time it was the policy of the federal government to dispose of all of the public lands over time. I'll talk about that in a minute. The more recent case that specifically addresses this question of whether the enclave clause or the property clause governs the ownership and regulation of the public lands is the case of Kleppe versus New Mexico. This was a case that was decided by the United States Supreme Court in 1976. And I'm sure a lot of you are familiar with this Kleppe case. The facts of this case were that the United States Congress had passed the Wild Horses and Burros Act. And that act applied to all of the federal lands, Forest Service and BLM. It also had application to private lands if private lands have wild horses or burros. There's a provision that requires that the government agencies and the private landowners work together to remove the wild horses or burros on the private land. But with respect to the public lands, obviously, it placed rigid protections for wild horses and burros. The state of New Mexico, on the other hand, had a state law that allowed wild horses and burros to be gathered and sold at auction. So you had a conflict between federal law and state law. A rancher who had a grazing allotment, had a permit, and a water source on that allotment, went to the land board in Nevada and said that he had wild burros that were using his water on the allotment and competing, obviously, with his cattle, and asked that land board to remove those wild burros, which they did. And after they did that, they went in and sued the federal government, claiming the federal government had no jurisdiction or authority to pass the Wild Horses and Burros Act. So it was actually the state of New Mexico that took the initiative. The Supreme Court rejected the argument, and the argument that was being made was based upon the Enclave Clause. The state of New Mexico said that the Enclave Clause did not give the federal government authority to pass the Wild Horses and Burros Act, so therefore the act was unconstitutional, and therefore state law, that is New Mexico law, should apply. The Supreme Court of the United States rejected that argument. And I'm reading now from a portion of that decision. In arguing that the act encroaches upon state sovereignty and that Congress can obtain exclusive legislative jurisdiction over the public lands in a state only by state consent, appellees have confused Congress's derivative legislative power from a state pursuant to the Enclave Clause. Federal legislation under that clause necessarily, under the Supremacy Clause, overrides conflicting state laws. And here, though the act does not establish exclusive jurisdiction over the public lands in New Mexico, it overrides the New Mexico estray law, which was the New Mexico state law, insofar as that statute attempts to regulate federally protected animals. The Supreme Court took this circumstance, however, and discussed very broadly the powers of the United States government under the Property Clause as it relates to the public lands. And in doing so, the court reviews the history of all the Supreme Court decisions that have been decided on that question. And what you see up on the screen is the final conclusion of the court, which said, "And while the furthest reaches of the power granted by the Property Clause have not yet been definitively resolved, we have repeatedly observed that the power over the public land thus entrusted to Congress is without limitations." That's still the law. And what it means is that with respect to the public lands, the Congress and the agencies designated by the Congress or empowered by the Congress, namely Forest Service, BLM, National Park Service, etc., have the right to pass regulations limiting or governing any use of the public lands. There is a question, and there are arguments that can be made, that the Property Clause under the Equal Footing Doctrine can't be that broadly construed. There are also arguments that can be made that under the Utah Enabling Act, which was the contract between the state and the federal government at the time of statehood, that Enabling Act required the United States government to dispose of the public lands over a period of time. And those arguments are probably going to be made. in a court of law. Those decisions are under consideration. They've not been made yet. But even if those arguments prevail, it does not change the fact that as long as the property, as long as the public lands are in the ownership of the federal government has the ability to govern those lands' use, or for that matter, prohibit those lands' use. The next question that we looked at, and this is again an issue that was raised in these some of these presentations, and that is whether historical uses of grazing lands, even uses prior to the passage of the Forest Service Act and the Taylor Grazing Act, whether those historical uses created some kind of a right to the range or to graze on the range over and above any rights you get with a permit. As you know, when the West was originally settled after the Louisiana Purchase and the treaty with Mexico, the West was enormous, and it was almost all public land. I mean, it was all either deeded to the lands from France or deeded to the United States by Mexico in the Treaty of Guadalupe Hidalgo in 1848. But in any event, there was this huge territory, this huge area was federally owned, and the federal government at that time was trying to encourage people to come out and settle the West. That was their objective for over 100 years. And as a result, the federal government just allowed ranchers, be it sheep or cattle or whatever, to run cattle anywhere. And that was the case until the federal government started to create forests, these forest reserves. And they started to build in controls, setting up grazing districts, limiting number of head of cattle or sheep or whatever. BLM gets authority to do that under the Taylor Grazing Act of 1934, as you know. But in any event, the question becomes, what, if any, rights does a grazer have by historical use, sometimes generations of historical use? The United States Supreme Court dealt with that issue early on. In the case of Light versus the United States, this was a case decided in 1911. It dealt with the Holy Cross Forest Reserve in, I believe it was California and Nevada, California, I think. In any event, and the forest had set up, using the authority of the Forest Acts, grazing districts, which limited the number of cattle that the public could graze within that forest. And a gentleman by the name of Fred Light, who was a rancher, who owned about 540 acres adjacent to the national forest, allowed his cattle to migrate, because there was no fencing, onto the forest. He had something in the neighborhood of 500 head of cattle. The United States government sued Mr. Light to enjoin him from allowing his cattle to graze on that public land, that is the forest. Mr. Light argued that the public lands were held in trust for the people, and that therefore the Congress could not restrict the use of the public lands. Does that strike a familiar chord? The United States Supreme Court first held that the historical usage did not create rights. And up on the screen, you have a quote from the case, and I'll read it to you. And this talks about this history. It says that common law, the owner was required to confine his livestock or else was held liable for any damage done by them upon the land of a third person. That's really the old English law and the law that applied in the colonies in the early states on the East Coast. It goes on to say that law was not adapted to the situation of those states where there were great plains and vast tracts of unenclosed land suitable for pasture, and so, without passing a statute or taking any affirmative action on the subject, the United States suffered its public domain to be used for such purposes. There thus grew up a sort of implied license that these lands, thus left open, might be used so long as the government did not cancel its tacit consent. Its failure to object, however, did not confer any vested right on the complainant, nor did it deprive the United States of the power of recalling any implied license under which the land had been used for private purposes. The Light case goes on to talk about the property clause. And let's go to the next slide. Regarding the property clause, the United States Supreme Court said as follows: the government has, with respect to its own lands, the rights of an ordinary proprietor to maintain its possession and to prosecute trespassers. It may deal with such lands precisely as a private individual may deal with his farming property. It may sell or withhold them from sale, and if it may withhold from sale and settlement, it may also, as an owner, object to its property being used for grazing purposes. For the government is charged with the duty and clothed with the power to protect the public domain from trespass and unlawful appropriation. Once again, reaffirming the government's rights under the property clause with respect to grazing. Lastly, the United States Supreme Court said as follows: the United States can prohibit absolutely or fix the terms on which its property may be used. As it can withhold or reserve the land, it can do so indefinitely. It is true that the United States do not and cannot hold property as a monarch would or may for private or personal purposes, but that law does not lead to the conclusion that it is without the rights incident to ownership. For the Constitution declares in the property clause that Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States. The full scope of this paragraph has never been definitely settled. Primarily, at least, it is a grant of power to the United States to control over its property. Another case that we found dealing with this same question of historical usage is the case of Gardner versus Stager. This was a Nevada District Court case that was decided in 1995. The Gardners were Nevada ranchers. They ran cattle on the Humboldt National Forest. They sued the government to quiet title to their right to graze on the national forest. In other words, they were alleging that because of the historical use of those grazing lands for pasturage, that they had acquired vested rights, and they were suing the federal government to quiet title or prove up those vested rights. They argued that their predecessors had grazed cattle since at least 1872, and that therefore they had vested rights. The court ruled that this argument, and I'll quote, flies in the face of a century of Supreme Court precedent. The court went on to rule as follows. Thus, the fact that their predecessors grazed stock on the land at issue in the 1870s does not mean that the Gardners today have a vested grazing right, a right of pasturage, immune from federal regulation. On the contrary, use of public lands for stock grazing, either under the original regime of tacit consent or under the permit system after establishment of the national forests, was and is a privilege with respect to the federal government, revocable at any time. The Gardners' use of the federal land is subject to regulation by the federal government. If they believe the federal government is acting unfairly or unwisely, the appropriate course of action is to take the complaint to their elected representatives in Congress. In short, the courts of this country have made it clear that usage of the public lands, whether under permit or otherwise, over a long period of time, does not in and of itself vest any protectable property right in the rancher. Another argument that was made at least one of these presentations was that the fact that a rancher has water rights on a cattle allotment in and of itself creates some rights to graze, at least in the vicinity of that water. As you know, water law is a state issue. Unless the government has reserved a piece of the public land and therefore has reserved water rights, the government of the United States recognizes and will not interfere with water rights. Under the 1866 mining law, grazers and other persons having water rights were also given rights of way for the conveyance of waters. That's the same act that the RS 2477 rights of way are under. So there's no question that the federal government recognizes your water rights awarded by the doctrine of appropriation or prior appropriation under state law. The question, though, is whether those water rights and the conveyances of those water rights through the public lands, through grazing lands, carry with them some right of pasturage. The United States Court for the District of Columbia in 2006 addressed that very issue. This is the case of Colvin Cattle Company versus the United States. The Colvins owned 520 acres of a cattle ranch in Nevada. So they had privately owned acreage of 520 acres. They also held a grazing permit from BLM to graze on the Montezuma allotment, which was 625,000 acres. They also held stock watering rights on the allotment. The Colvins stopped paying their grazing fees at one point, but they continued to graze cattle on the allotment. Their permit was canceled, and they were ordered to remove any of the range improvements that they had installed. The permit on that allotment was issued to another rancher. The Colvins alleged that the canceling of their grazing permit and the fact that they no longer could raise cattle and use their water source and conveyance system, that constituted an unconstitutional taking of their property rights, not only in the water, but also in the grazing rights. The court held that no property right can be acquired by grazing upon the public lands, restating the law that was set forth in the Light case. And the court stated, and you've got it up on the screen, I hope, to the extent this, pardon me, that's not the one I wanted. This is what I want to read to you. The court said, no property right can be acquired. This is not what is up on the screen. No property right can be acquired by grazing livestock upon the public domain. All persons so using the public domain do it merely by sufferance of the federal government. This use is often alluded to as a right. It is not a right that the government of the United States has conferred, and these public rangelands may at any time be withdrawn from such use. With respect to the question of the water rights and whether the water rights gave the Colvins a right to graze on the public lands, the court stated as follows. To the extent the Stock Watering Act, and you're all aware of the Stock Watering Act that was passed early part of the, later part of the 19th century, I guess, early part of the 20th century. To the extent the Stock Watering Act purported to govern the grazing use of the public land, it was superseded and rendered ineffective by the enactment by Congress of the Taylor Grazing Act. Therefore, because Colvin's water rights do not have an attendant right to graze, no governmental action restricting Colvin's ability to graze on federal land can affect its water right in a manner cognizable under the Fifth Amendment. So the courts have stated clearly that the fact of ownership of a water right on an allotment does not carry with it any grazing rights beyond those that are contained in the permit. The 10th Circuit Court of Appeals, which governs the state of Utah, has ruled also to that effect in the Diamond Bar Cattle Company versus the United States case that was decided in 1999. Now, the last case I want to talk to you about, and I'm sorry if this is boring stuff because I'm reading you a lot of case law, but it's important that you understand what the law really is and what the courts have really said. The last case is a case that I'm sure that most of you are aware of. It's United States versus the estate of Wayne Hage. I know that most of you are aware of the battle that has been going on between the Hage family and the federal government since 1991. There have been several lawsuits that have been brought. There have been several decisions rendered, some going in favor of the Hage family, some going against. But in a decision that was handed down just this year, in January, the court, and this is the 9th Circuit Court of Appeals, addressed a lot of the arguments that were made in one of the presentations that I originally alluded to, because the presenter was close friends with the Hage family and I believe participated in formulating a number of the arguments that were made by the Hage family. Very briefly, the facts of the Hage case as far as that particular decision is concerned, that most recent decision, were as follows. The Hage family, that is Wayne Hage, began running cattle on BLM land and Forest Service land in 1978. They did so pursuant to a grazing permit. In 1993, because it was alleged that the Hage family had not complied with the terms and conditions of the permit was not renewed when it came up for renewal, that is in 1993. The Hage family continued to run their cattle on both the BLM and the Forest Service. And the United States government sued, asking for damages for trespass and for an injunction to prohibit further grazing on the public lands. The lower court had ruled in the Hage family's favor. So when it got to the 9th Circuit, the Hage family was actually in the stronger position, but the 9th Circuit basically rejected the arguments that were waged by the Hage family dealing with their rights, their grazing rights, outside of the permit that they might have had in the public lands. Hages argued that water rights carry implicit, appurtenant grazing rights. And the court address that issue as follows. And they make reference to a case of Hunter versus the United States. And they said in that case, that is Hunter, we held that pursuant to the Mining Act of 1866 and another act, an owner of water rights possessed of a right-of-way over federal lands for the purpose of diverting water by the construction of ditches and canals. But we made clear that an owner of water rights possessed a right-of-way only for those diversionary purposes. We expressly rejected the rancher's argument that water rights entitled him to an appurtenant right to graze or to any additional or other easements. Accordingly, we held that the rancher is not entitled to an easement to graze livestock on lands within the boundaries of the federal lands, but that he should be allowed a right-of-way over those lands to divert water by one of the methods contemplated by that Mining Act of 1866. Now, the other issue raised in one of these presentations was the issue of RS 2477 rights, that is, rights of way for roads, and whether those roads or having those rights of way mean you have rights to graze. And again, this is an argument that was made in Junction, Utah, just 6 weeks ago, I guess. Let me just very quickly explain to you the way RS 2477 works. This Act of 1866 gave a right-of-way over public lands for any roads that were created basically in the settlement of the West, whether by miners, ranchers, homesteaders, whatever. The federal government, they were trying to get people out here to settle the West for a number of reasons. Revenues is one, and just plain holding on to the land is another. So they made it very easy as they could, to encourage people to come out west and settle. And they said if you build roads across public lands, because everything was public land at that point, that the federal government would recognize those rights of way, would recognize those roads. That law stayed in effect for 110 years until 1976. It was repealed by the federal government in FLPMA, but FLPMA also provided that any rights of way in existence in 1976 would continue to be recognized. And so what we're doing in these RS 2477 cases is trying to show which roads or which rights of way were in existence in 1976. The way you make that determination is complicated. There's so much that goes into it. But basically, when you're talking about most of these smaller roads, we have to show continuous use by the public for a period of at least 10 years prior to and continuous years by 1976. Once you establish a right-of-way, the right-of-way is limited to the right-of-way, the dimensions of the right-of-way that existed in 1976. So you get rights, but they're restricted to the right-of-way that was in existence in 76. That's the theory. One of the arguments that was presented in Junction, one of the arguments made by the Hage family was that they had, because of their use of the allotments, they had rights of way under RS 2477, and that those rights of way, in essence, gave them the right to graze above and beyond the permit. The court dispensed with that argument and stated as follows: defendants have not established a right-of-way pursuant to the revised statute RS 2477 in which the title given to Section 8 of the Mining Act, the right-of-way for the construction of highways over public lands not reserved for public uses, is hereby granted. Defendants have not shown any roads exist, let alone that Nevada established alleged roads as highways under Nevada law. The court went on to state that the granting of an RS 2477 right-of-way doesn't give you rights beyond the right-of-way for the road. That's it. It doesn't give any grazing rights, even if that road goes right through the middle of an allotment. So, where does that leave us? You know, we didn't go about this research that we did in an effort to disprove anything that we heard at these meetings. But the fact of the matter is, we didn't find anything that would support a grazing right on public lands outside of the permit system. We didn't find anything. And I know a lot of you don't want to hear that. But don't shoot the messenger. I'm telling you that that's the law. And I'm also, based upon this research that we've done, only more convinced that to surrender your grazing permits to the federal government under a theory that you nonetheless have a right to graze on the public lands finds no support in the law. No support that we've been able to find, none. And so I'll reiterate again that it would be against your financial interests, it would be against your family interests, it would be against all your interests to do that. I mean, if you want to make a protest and you think that's a great way to make a protest, you know, go for it. But there will be consequences. And if you try to graze on your allotment after sending back the permit, there will be consequences. And you're not apt to get that permit back. That's not the only problem, though, with returning a permit. If you return your permit to the federal government, you are giving the Western Watersheds Project and the Grand Canyon Trust a Christmas present. There is nothing that they would rather have you do. There's another point, and that is that if you signal to the public, to the government and the public, that you're going to send back your permit and you're going to thumb your nose at the federal government and you're going to go out and graze on the public lands, not the less, what does that do to the rest of you in terms of how the public is going to look at ranchers on the public lands in the West? Not well. There's a term that's used, welfare ranchers. It's horrid. It's horrid and entirely inaccurate. But let me tell you, that's what you're going to hear if you try to graze on the public lands without a permit. Look, I am with you on this. I am totally committed. I know there's some people that just think what I've been telling you is a bunch of nonsense. And you know, you can believe whatever you want to believe. We've done our best to ferret out the law and honestly advise you as to your rights. If you don't want to believe what we've said, if you don't want to believe this case law that I've reviewed, I can't do anything about that. But before you do anything, talk to a lawyer. Talk to a lawyer. Don't rely on academic papers. Don't rely on statements that are made by people that have no legal duty to you. In any event, one thing, and I'll wrap up right now, I know I've taken a long time. One of the things that I told the ranchers in Paiute County, starting with the first meeting and every meeting we've had with them, is that there are other ways that we can help, and we will help. And right after that first meeting back in November, when I got back to the office, first thing we did was talk about the various ways that the state of Utah, the governor's office, the attorney general's office, and the state legislature can help you guys. And we're following through. And I'll turn the time now over to Reg Johnson, who will tell you what we're doing. Thank you.
Not till after the presentation. When he's done, we'll come back. When Reg is done.
Thank you, Tony. Tony had a tough job this morning. There's been a lot of people out there talking about different rights that we have, and Tony and his crew did a good job of going and taking a look at that. I know it's not something everybody wanted to hear, but now you've heard both sides of the story, so I appreciate your insight, and David, thanks for the help you put into that too.
On the other side. We're on this side.
True. Thanks. I would like to thank Farm Bureau, Cattlemen's Association, the Wool Growers Association, everybody else that helped put this on, and mostly I'd like to thank the audience for showing up today. This is your livelihood, and we're going to be here to help you as much as possible. It does seem like somewhat of a friendly crowd. Reminds me of being back at the Cedar Livestock Market. Instead of me being in the ring, I guess I'm on a stage though. So you might wonder who I am, why the Public Lands Office has hired me to help you out. So I'm going to just give you a brief history of my family. My ancestors were from some of the first ones to come into the Sevier Valley, into Wayne County. We ran from the Henry Mountains up into Fish Lake. We were also one of the first families into the New Harmony area. That was 150 some years ago. Many of you out there have the same family history, and I'm a big history buff. I like to go back and read Father Escalante's journals, Kit Carson, things like that. When you go back and you read those journals and you see or you read and get the mental picture of what this area looked like before the pioneers came, it was desolate. There was very little. There was almost no forage. The forests, there was very little game. Over 150 years of your family and my family's stewardship, the lands have really blossomed. There's more forage now. There's more timber available. But unfortunately, we're not managing it as well as we could. And that's what I'm here to try and help both the ranchers, the other natural resource users, try to bring some balance back to this process. One thing I'd like to, just a little housekeeping thing before I get started into the presentation. In your packets on the left side, there's a letter from the governor's office. On the reverse side of that, there's a form called the Grazing Working Group, Public Lands Grazing Issues and Grievance Forms. We've asked, as Tony and I have been out talking to some of the different groups, to fill these out, because what that does is that gives us an ability to see what your issues are. And we're working with grazers across the state and going and working individually with them at every level of government and see if we can't come to some solutions for some of your individual issues, because that affects the industry as a whole. And that's a very large part of the state of Utah's economy, as Randy pointed out. You're in the billions of dollars in economic impact for the state, and that's a major concern for the governor's office, the legislature, and your local commissioners and your local communities. When you look at what your industry contributes outside of the Wasatch Front, in your counties, many times you're up 40, 50, 60% of these rural counties' economies. That's a huge impact, and so that's what we're here to help you protect, your livelihoods and your communities. So, can I borrow that mic? I'm going to step off to the side here because I can't see the presentation and go through it at the same time. Everybody here, I guess you can hear me. So as Kathleen and Tony have said, we're thinking about ways that we can assist you, both as individuals and as an industry. And times are uncertain out there, and one of the biggest challenges to any business, and I don't care whether you're in agriculture, banking, whatever your industry might be, uncertainty in the marketplace is a killer. And so that's what we're here to try and take a look at. The governor's office is dedicated to promoting responsible land management for the health, safety, and welfare of our citizens. Balanced management of your land is vital. You guys create a healthy ecosystem out there. Through grazing, you increase the biodiversity. If you look back at the histories that I've read, whether it's Kit Carson or Father Escalante, this land had no forage when the pioneers first arrived, and through proper grazing practices, we've allowed biodiversity to flourish. We have more plant life when we have more wildlife than we had during those days. I mean, Father Escalante almost starved to death trying to get through the state of Utah at one time. So if you look at what used to be available and what's available now, you guys have done an excellent job of managing these lands, so thank you for that. The product that you create, you're turning a inedible biomass into a high quality protein. You're giving me my boots, you're giving us our belts. So you guys are creating a lot of great things for our citizenship. Safety in the lives of property. Grazing reduces fuel loads. That can be a huge benefit when you're talking about wildfires, talking about protecting your cabins that are in the mountains or your farms that are out there, or communities at large. There was a wildfire that came off the top of Pine Valley Mountain a few years ago and almost took out the town of New Harmony. That area had not been grazed, there had not been the fuel reductions needed, so it has a direct impact, not just on people that are living on the land, but also people that live in small communities around the West, and even folks that might live in the Wasatch Front. Another thing that a lot of people overlook that you guys provide is you are the search and rescue people out there. A lot of times when people from the urban areas come out, they get lost. The first people that they call are you guys because you know the land, you have the horses or the ATVs that might be needed to get into the backcountry to help these folks out. So you provide a lot of benefits to the community that way. The welfare of our citizens and communities. Randy mentioned a little bit about the economic impact. I was down here meeting with some folks last week with the Forest Service, and they shared, this is just one ranching family, shared their contribution just from last year, and it was over $600,000 that they had brought into the community. You guys are the economic backbone of most of these rural areas, and the more we're seeing suspended AUMs, the more we're seeing stress and uncertainty in your industry, the harder it is for you to keep supplying the jobs, to keep supplying our beef and our leather and other commodities. One of the interesting things that we never hear from the NGOs out there that are against grazing is, let's face it, grazing was probably the first green industry. You're turning biomass into protein and other things that we can use. So kudos to you, and I hope you don't mind me putting you on that green industry list because I know some of you don't like that, but it's true. So what is the Grazing Resolution Group here to do? As Tony said, we started talking a few months ago about what we were able to do, and we knew we needed a team that covered people from across the state, different levels. So it's the governor's office, and I was asked to chair that. We also have the Attorney General's office as part of that for the legal review. Department of Agriculture has been a great partner. County commissioners have been very supportive. Division of Wildlife Resources, there's a lot of issues that are predation, depredation, things like that. They were great to send Bill Bates over to sit on our committee. And the congressional staff. The congressional staff has been very involved with this, and we're inviting them to come out to the meetings with us. You know, we have a unique opportunity right now. A few weeks ago, there was a congressional hearing down in St. George. The congressional staff and our congressional representatives are very involved right now in the grazing and public use, natural resources of our public lands. Quite unique. I've been in this arena since I was about 12, 14 years old. Some of you may know Matt Johnson, who used to own the livestock market in Cedar City. That's my family. He's been supportive of your industry and other natural resources for a long time. And so I've grown up with a background of these issues where it's RS 2477, water rights issues, grazing, mining, et cetera. And Farm Bureau's also been a great partner in this. So I want to thank them as well. So the objectives of the grazing group. We realize that there are a number of issues, and we're not going to be able to solve all of the problems. So we're concentrating on kind of this list that we have right here. When we were at these meetings, we got about 60 responses out of around 70 grazers. And we were able to take it down to these basic 5 right here. Reinstatement of suspended AUMs. Whenever there's a drought or certain conditions on the ground, there's this immediate reduction in AUMs. And what we're asking for is that as we move into a wet period, that we get these suspended AUMs put back. There's often not a NEPA process done when there's a suspension, and so we're asking that they just put these back in. We're looking right now at a really good water year. By raise of hands, how many people out there have been contacted by their Forest Service or BLM about putting back in some suspended AUMs? That's what I thought. So that's what we're here for. I mean, right now we're looking at a great water year. And what does that mean? That means a great forage year. So why isn't the BLM or Forest Service contacting us right now saying, hey, we're going to have some good forage out there. Let's get some of those suspended AUMs back, even if it's 2%, 5%. Yeah, we're in 5-6 year drought. It's going to take a while to come out of it, but 1 year, you guys know, you're on the ground, one good water year and you're going to have extra forage, so why can't we utilize that? Fair conversion rates. As many of you know, conversion rates, sheep to cattle, should be around 5 to 1. We're often seeing conversion rates come back 10 plus to 1. I think the worst I saw was an 18 to 1. That's just not acceptable. You guys shouldn't have to take a cut in your permits just because you're converting from one to the other. We're also asking that those conversions, when they're done, remain common allotments. A lot of times we can run sheep and cattle on the same allotment and end up with a better utilization of the forage than having just one or the other. So that's another thing we're looking at. Protect access and trailing. Tony brought up a little bit about the RS 2477 issues. We need to be able to access these public lands in order for you to run your operation, in order for you to get to your springs, get to your corrals, to fix them up, etc. So our office is working diligently on that, and there's some trailing issues. Many of these families have been trailing, like around the Cedar City area, Wayne County, for over 150 years. There's no reason that just because somebody, either at Washington or somewhere else, thinks that you should no longer trail through there, that you should have those removed. So we're working with individuals trying to protect those trailing routes. Depredation and predation. There are a lot more elk now than there used to be, and we're trying to work out with folks how we balance that. Now, I would like to mention one thing while I'm on that. We're mostly livestock folk here today, but we can't win this public lands battle with just livestock. We have to have the sportsmen with us. We have to have the timber folks with us. We have to have the ATV folks, etc. with us. We need a coalition that's stronger than just one group. If we don't, we're going to end up with what happened to logging in the state of Utah 40, 50 years ago. We need to stay together as a team who uses the public lands. And if we don't do that, most likely industries or uses will be picked off one by one. EAs and EIS reviews of allotments. As Kathleen was saying earlier, our office does this day in and day out. We try to take a look at these every time they come up, see what the issues are, and see if we can't provide some coordination through the state agencies with you to make sure that the EAs and EISs are successful and keep you in business. We're also looking at ways we can provide assistance, and a lot of times what we need is better science on the ground. And there will be people throughout the day talking to you about monitoring your allotments, taking photos, things like that. We're working with a couple folks right now who've been out taking pictures of the same location throughout their allotment for over 20 years. That gives us an excellent documentation to work with your federal partners to say, no, this ground hasn't been overgrazed. It might be overgrazed at one season, at one time, but if you look at the next spring, the grass is back up the same as it's always been. In some cases, back better. So the more you guys can do to document that stuff, the more help it's going to be for us. So I guess I jumped ahead a little bit. This is the documentation slide. So this is up on the Boulder Mountain. They've been taking a look at the willow utilization. As you can see, they're doing a great job there grazing. The grasslands are in good shape. Their riparian area is in good shape. The willows are in good shape. There's not much wrong with it, but unless we have documentation, and this rancher has been doing this for a number of years, goes out, that's a time-stamped photo, GPS location, so we can go back there year after year and see what's going on. And he has documentation of it year after year. So monitor your allotments. It's one of the best things you can do to keep yourselves in business. Documentation. These forms, I think Troy Forest or USU Extension or the Forest Service and BLM can get you these forms. use them. Make sure that every year you have that documented, and don't rely just on what your range cons are doing. I'm not going to say they're the other side, but if you don't have your own documentation, if there's a discrepancy and you go to court over it, and the only one that has documentation is the federal agency or somebody else, it's going to make it much more difficult for you to get satisfaction in court. Communication. Make sure that you're communicating with your federal agents, with our group, with the state office, with the Department of Agriculture, USU Extension. There are a lot of tools out there, a lot of places that we can work together and help you out. But we need that back and forth communication, and that's why it's vital that you fill out those forms that we've put in your packet, and I will have a box out in the lobby area at the end of the day so that you can drop those off. If you don't have a chance to fill them out today, you're welcome to send them in with the addresses on the back. So another aspect that I'd like to talk to you about today is the county resource management plans. It's another program that I'm in charge of, is helping the counties create these management plans across the state. And it's planning for the economic success and ecological health of our state's natural resources. And one of the reasons why this is so important is under Congress, under FLPMA and NIFMA, there is language that says that the federal agencies are supposed to take county and state plans into consideration to the greatest extent possible under the law to make them consistent. Thank you, Kathy. So one of the big issues we've had, though, is since this act passed in 1976, we have not had detailed county plans at the local level or detailed state plans that have forced the federal agencies to be consistent with them. I hope Brian Bremner from Garfield County doesn't mind me using this experience, but about 5-6 years ago, he took his county plan into a federal agency and said, you guys are inconsistent, and here's my plan on this issue. I would like to make you, or I would like some coordination with you and try to work this out. And he went back 2 days later, and the gentleman said, well, I appreciate you bringing your plan in, but there's nothing here that I can work with. It was just basically a wish list of what the county wanted. So since then, Brian Bremner has been one of the biggest proponents of these county resource management plans, and his plans are, getting up in the 300 or 400 page area, well documented. The science is behind it. And that's what we're looking at, is making some very detailed plans that cover the 27 resources under the county resource management plans. Then we're going to take the 29 counties plans and roll them up into a statewide plan. This whole planning process was attempted back in the late 1990s, but it was kind of a state-down approach. And it didn't really work out because when the counties saw it, it wasn't specific enough to the county issues or to the industries in those counties and how they wanted to see that rolled up. So this time around, it was done the reverse. It was given to the counties to make the first attempt at the county resource management plans. And I gotta say, that's the best way to do it. These counties, you guys as individuals out there on your allotments, on your property, at the county level, no more than the state agencies or even the federal agencies will know about those lands. You're there every day. You know the resources, you know where the water is, you know where the grass is. So let's work from the local level up, and then we'll try to wrap the 29 counties together into a statewide plan. But that will give us another tool that we can use when we're working with the federal agencies to say we have a plan in place. And according to these laws, you need to be as consistent as possible under the law with the local plans. It was passed by Congress. It was one of the things Congress did for you. But we need to use it to our benefit. And so I hope you'll get involved with the county resource management plans. Most of them are kind of drafting right now. Some of them, like Brian Bremner, are a little further ahead. But now's the time to get involved. There's 27 named resources there on the screen. You can read through most of them. There was actually going to be one more added. It'll be air in this session. That just came out of rules. So You have some direct opportunities. You see livestock grazing, agriculture, irrigation, water rights, and forest management, ditches and canal. Those are all that really are specific to you. There's indirect opportunities too: wildfire management, land access, land use, wildlife, and not least, economic considerations. So I hope you'll get involved with these the planning process. It is there to help you out. And if we don't get your input, then it makes it more difficult for us to help you out in the long run. The counties and the state need your institutional knowledge. When I look out here across the auditorium, I see the institutional knowledge of the state of Utah when it comes to grazing. So make sure that you use your knowledge to the benefit of your industry and to the benefit of the state and the benefit of your communities. Best practices, local knowledge, historic uses, and economic considerations. So that wraps up what I have. I think you wanted to open it up for some questions if we have time.
Go ahead.
Nope.
I'm sorry, I'm gonna have to play tough here. We have gone past the allotted time. If you go, Matt, if you've got a question for Tony, grab him at lunch. But to be, you know, fair to our other presenters, we've got 50 pounds of potatoes to put in a 25-pound bag today, and we need to stay on target as best we can. So, thank you. Please give them a round of applause. I'm guessing everybody out there in the audience has questions for Tony, right? Yeah. He will be around. Greg? You have somebody with you, or?
I do, but I think they'll just stay up
Okay.
there if that's okay.